Welcome to the Parham Estate Law Podcast.
Welcome to the Parham Estate Law Podcast with Mike Parham. Mike is the founder of the Parham Estate Law and Tennessee estate planning attorney who helps individuals, families, and business owners protect their assets, plan for the future, and avoid unnecessary complications. I'm Evan Mack, and today we're talking about how to avoid probate in Tennessee and what strategies actually work for families who want to make things easier on the people they leave behind. Mike, welcome, sir.
Thanks, Evan. Good to be here.
So Mike, before we get into probate and estate planning, can you share a little bit about your background and what led you to focus on, your practice on this area of law?
Well, when I first got out of law school, I was working for a law firm and I was doing a lot of litigation. And I found out very early on that I did not like litigation. Litigation, by its very nature, involves conflict, and I didn't like that. Everybody was mad. They're mad at each other. They're mad at you. But during that first year or so, I did a little bit of estate planning work and probate. And I found out that line of work, you're really just helping people. It's illegal. There are legal issues that they need help with, but there's no bad guy and good guy. You're just trying to help. And I really like that. So I spent my entire career focusing on that area.
So Mike, probate is something many people want to avoid, but there's still a lot of confusion around it. What is probate in Tennessee, and why do families often want to stay out of the process if they can?
Well, first of all, probate involves a will, last will and testament. A last will and testament is just a document that somebody prepares that states how they want their assets to pass at their death to their family, to charity, or whoever. In that document, they name the person who will administer the estate, which is most of the time known as an executor. Now, when somebody does a document that they call a will, it's not officially a will until a judge gives an order saying that it is. That is part of the probate process. The probate process involves taking the will to court. The person who is going to be the executor is usually the petitioner, and the judge gives an order admitting this document to probate as the official will. Until the judge gives the order saying that this is a will, it's not officially a will. Then the judge will give an order appointing this person as the executor of the estate. At that point, the court will issue what they call letters testamentary to the executor that gives that person the authority to act on behalf of the deceased person. The executor is basically the deceased person's representative in carrying out that person's wishes regarding their estate. So at that point, the executor has letters from the court that allow them to go to banks, have access to bank accounts, allows them to sell real estate, allows them to change title on cars. And then during that process, they will pay any bills, medical bills that are outstanding. They will file any tax returns. And when everything has been taken care of, then they will distribute the assets, whatever's left after paying expenses, to the beneficiaries. Once that is done, then they can close the estate and the probate process is over. But basically, probate is just the administration process of carrying out the person's wishes that they stated in their will.
So what are some of the biggest misconceptions people have about what happens after someone passes away, Mike?
Well, there's a lot of confusion about what really controls. Some people think, well, I have a will. The will says I wanted my assets to go to this certain person, but they have beneficiary designations that say that it goes somewhere else. One of the biggest hang-ups is if somebody has been divorced and remarried, but they neglected to change the beneficiary designation on their insurance. If they name their ex-spouse as the beneficiary, it doesn't matter what their will says, that ex-spouse is going to get that money. Another thing that is a misconception is that I've heard people say, well, I don't have to go to probate because I have a will, when it's the exact opposite.
So a lot of people assume having a will means their family will avoid that probate automatically, Mike, but what does does a will actually accomplish in the state of Tennessee?
Well, it states it's a good document because it states the person's wishes specifically. Sometimes people, they have a house that they want to go to a particular child. That child has been living with them and they want that child to get that house by themselves. If they don't have a will, you can't do that. under Tennessee law, if you don't have a will, your estate is going to pass by what they call intestate succession, which means if you're married, your spouse will get 1/3 of the estate, and your children, if you have two or more, will divide up 2/3 of the estate. Most people, when they're married, if they die, they want their estate to go to their surviving spouse first and then to the kids at the second death. But that doesn't happen unless you have a will. Also, if you want to leave some money to charity through your estate, you have to have a will, because charities do not show up anywhere under the intestate succession laws. You have to have a will to do that.
So, what are some of the most effective ways to avoid probate in Tennessee?
Well, the most effective way is to execute a revocable trust. A lot of times these documents are known as living trust. A living trust is a document that the person signs that takes effect immediately. When they sign this trust, they transfer their assets to the trust. They transfer their real estate, their bank accounts, investment accounts. But this trust is revocable, and also the person is the trustee, so they maintain complete control of their assets. But if they become incapacitated or at their death, then the successor trustee that they've named can take over. What this accomplishes is that the assets have already been transferred to a trust, which means that you don't need the probate process to transfer it from the person to the beneficiaries. It's already in the trust. The assets just go straight from the trust to the beneficiaries.
Besides those trusts, are there any other assets or accounts that can pass to a family member without going through probate?
Well, you can name people as beneficiaries. You can name a person as a pay on death designee on a bank account, or a transfer on death designee on an investment account. The thing I don't like about those techniques is if you have multiple children, almost every family that I work with, no matter how many children they have, there's always the one child who is the responsible person. When the mother or father dies, the entire family knows that this person, this daughter or son, is going to be the one who's going to take care of everything. If you try to avoid probate by making all of your children beneficiaries on your liquid accounts, then the only thing that's going to be left is illiquid assets like your house. Well, this person is having to deal with getting the house ready. Most of the time, that's going to involve money. You got to have money for repairs, pay the property taxes, pay the insurance. Well, what are they going to use for money? They don't have any. It's all been divided out among the children. So now that person is going to have to go to all the siblings, try to get them to kick in some money to pay these expenses, and it just creates a big hassle. Sometimes people will say, okay, I know this one person is going to be handling everything, so I'm going to make that one child the joint owner on my accounts, or maybe make that one child the pay on death designee or the beneficiary of everything. There's two problems with that. One is, if you leave everything to one child, then you're putting the onus on that child to divide everything up with the other children. They don't have to do that legally. If you make that child the beneficiary, the money belongs to that child. So you're just depending on their good nature to be fair with the other children. Now, a lot of times they do that. But if they do, now you've created a gift tax situation for that person, because the money they're transferring to the other siblings is now a gift from them. It's their money that they're giving to their siblings. That's a gift. It can be taxable. Another issue with making a child a joint owner on an account is liability issues. I had a family recently that they made their son the joint owner on their bank accounts to make things easier for probate. That child had a DUI. He had a wreck. He was killed in the wreck. 2 other people were killed in the wreck. There's going to be massive lawsuits. Those assets that they made joint with their son are going to be subject to collection in this lawsuit. So they've endangered their assets by making him a joint owner on the account. So there are other ways you can avoid probate that people utilize a lot, but there are many issues with those, and I don't prefer that they try to avoid probate in that manner. I think it's better to go through the probate process rather than try to avoid it by making people pay on death designees or beneficiaries.
So, Mike, you kind of touched on one, but do you have an example or a situation where proper planning helped the family avoid major delays, complications, or unnecessary expenses after someone passed away?
Well, I have one family. Uh, I'm in Memphis, Tennessee, and so Memphis is on the border of Arkansas and Mississippi. So we have a lot of people who own real estate, not only in Tennessee, but also in Arkansas and Mississippi. If you have real estate in multiple states, not only are you going to have to go through probate in your home state, but also you're going to have to go through what's known as ancillary probate in the other states where you own real estate. So you could have not only one probate administration, but maybe two or three to handle all these different pieces of real estate. By having a living trust, you can title these properties into the trust. So at the person's death, they don't have to, not only do they not have to go to probate in their home state, but also in any other state where they own real estate. Another thing is that people are living so long now. It's not unusual for people to live into their 90s or past 100. And when people get to be that age, a lot of times they start to rely on their children more to help them paying bills and handle their finances. With a living trust, you can name a child as a co-trustee. You haven't put the assets in that child's name. You've just given that child the ability to administer these assets during your lifetime. So if a person develops dementia, Alzheimer's, has a stroke, that child is already in the position to take care of the parent through means of the trust.
Thank you so much for the information and time, Mike. Appreciate you.
Thank you.
All right. That's it for today's episode of the Parham Estate Law Podcast with Mike Parham. If you'd like to learn more about estate planning, trust, probate, avoidance, or protecting your family's future in Tennessee, visit ParhamEstatelaw.com. Thank you for listening, and don't forget to subscribe, leave a review, and share the show with someone who might find it helpful as well. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.